Welcome to the sample lesson on offer and invitation to treat. For a detailed analysis of the related doctrines in contract law, consider our dedicated video lecture, which examines the foundational doctrines that govern pre-contractual statements, the formation of contracts, and the remedies available when things go wrong. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. 1. Offer versus invitation to treat. The formation of a contract begins with the distinction between an offer and an invitation to treat. This distinction is central because only an offer is capable of acceptance. As explained by McKendrick, an invitation to treat is simply an indication that a party is willing to enter negotiations. It does not bind the party to the terms expressed. The general rule is that advertisements are invitations to treat, as illustrated by decisions such as Partridge, where a newspaper advert listing certain birds for sale at a specific price was held not to be an offer. The rationale is that advertisements usually indicate willingness to receive offers rather than a commitment to sell to anyone who replies. However, the rule is not absolute. Courts have recognized that advertisements may constitute offers where the language used demonstrates an intention to be bound. The classic example is Carbolic smoke ball, where the manufacturer's clear commitment to pay a reward created an offer to the world. Later case law, for example, Bowerman and Association of British Travel Agents, has also recognized that notices displayed in a commercial setting, such as a travel agency, may amount to an offer where the terms are clear and intended to bind the business without further negotiation. The practical effect is that courts examine the intention of the party making the statement. As established in Gibson and Manchester City Council, a social housing case, if the language indicates finality rather than negotiation, the statement is more likely to be treated as an offer capable of acceptance. Entores and Miles Far East Corporation, an instantaneous means of communications case, and Scammell and Nephew and Ouston, a certainty of an agreement case, where a customer entered into negotiations to trade in his old van, are authorities that once an offer is made, acceptance must be unconditional and clearly communicated. When acceptance is expressed without qualification and the agreement is sufficiently certain, a binding contract is formed. 2. Terms of the contract. Distinguishing terms from representations. Once a contract has been formed, the next step is identifying which pre-contractual statements have become part of the contract as terms. Contract law distinguishes statements of mere opinion or puff representations and contractual terms. A term is a statement intended to be binding. Whether a statement becomes a term is determined objectively by considering the importance of the statement, the party's intentions, and the context in which it was made. As clarified in Couchman and Hill, where at issue was whether a heifer was unserved, meaning not pregnant, courts ask whether the statement was so significant that, without it, the party would not have entered the contract. A representation, by contrast, induces entry into the contract but does not become part of the contractual obligations. The question of comparative expertise often guides this assessment. In Oscar Chess, the court held that a seller's incorrect statement about a car's model year was a representation, not a term, because the buyer was a car dealer with greater expertise. Conversely, in Dick Bentley Productions, a car dealer's statements were held to be terms because the dealer possessed specialist knowledge on which the buyer, a layman, reasonably relied. The overarching principle is that the more one party relies on the skill or judgment of the other, the more likely the statement will be treated as a term. We hope that this sample lesson was helpful to you. This lecture will continue in our dedicated video on offer, invitation to treat, terms, representations, misrepresentation, breach and remedies. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.